Hi, good morning everyone. My name is Lindsay Gray and I am one of the attorneys at Whitlock & Gray and I am located in the Austin, Texas office. I'm here to talk today about how a DUI could affect someone's immigration status. While a DUI is not specifically its own grounds of inadmissibility or deportability, it can have really serious effects on someone's immigration status. So that's what I'm going to talk about today. First of all, in late 2015, the Department of State published guidance that said that they should prudentially revoke all visas of someone who has a DUI arrest. So if someone is here on a student visa or a work visa like an H-1B, and they're even just arrested for a DUI, oftentimes now the Department of State is revoking that visa. So the person cannot travel and then re-enter the United States because their visa has been canceled. This can also affect the person's period of authorized stay. It doesn't necessarily mean that the person has to leave the United States right away, but it can have a negative effect on that. It also can have a negative effect on green card applications. If you apply from within the United States for a green card, you're generally filling out a form called the I-485, and that form can be denied on the basis of discretion. So if someone has a DUI, it's possible that an immigration officer would deny the green card application on the basis of discretion. Another possible grounds of denial, whether inside or outside the United States, is there's a grounds of inadmissibility called habitual drunkard. Now, you would think that the habitual drunkard ground of inadmissibility would only apply to people who have multiple DUIs. However, sometimes it doesn't. Sometimes, and just like the visas being revoked, they can revoke a visa or deny a green card, or in some cases send a client to a panel physician in order to determine that they are not a habitual drunkard. And in fact, the Department of State will sometimes send people, so the Department of State outside the United States will sometimes send people to a doctor to confirm they're not a habitual drunkard, even if they only have one DUI arrest. This can cause major problems. It can cause delays in cases. And so the DUIs really can negatively affect these type of applications. Also, if someone is already a green card holder and is applying for citizenship, it can affect their finding of good moral character. So generally, someone, when they're applying for citizenship, has to prove that they have demonstrated good moral character within the past 3 years, or the past 5 years, depending on how many years since their admission as a green card holder, and now that they're applying for citizenship. So in the St. Louis, Missouri office, for example, the officers are generally not, or going to be very skeptical of granting a citizenship application if someone has a DUI within the past 5 years, and sometimes even if they've been on probation for that DUI within the past 5 years. Our office has had success having someone be granted naturalization when they've had a DUI within the past 5 years, but it takes considerable effort and documentation of proof of rehabilitation, completion of probation, those kinds of things. Another time in which someone has to prove good moral character is when they're applying for cancellation of removal in immigration court. And again, a DUI can affect that application. So you would want to prove rehabilitation, proof of completion of probation, and in the end, a judge could deny it on the basis of finding lack of good moral character, depending on the circumstances surrounding the DUI. Another way that a DUI can affect immigration court is bond. There's a recent case that came out reiterating that judges should consider DUIs as negative factors in bond proceedings. We have had success with clients with one DUI, especially if the DUI is fairly old, getting them a bond in immigration court. But judges do not have to grant bonds to people with DUIs, and especially depending on their recency, it can cause quite a lot of problems. Another way in which a DUI can affect someone's immigration status is with DACA and temporary protected status. Now, USCIS is no longer accepting initial DACA applications, but they are accepting renewal of DACA applications. And of course, there are still people who currently hold the DACA grant that they had before the administration announced that they would no longer be accepting new initial applications. DUI is considered what's called a significant misdemeanor. And significant misdemeanors, they have a definition and a list of different types of convictions, but a DUI is one of them. And both DACA and TPS, temporary protected status, require that the individual not have been convicted of any significant misdemeanors. So if someone has a DUI conviction, they will not be eligible for DACA or TPS, or those things can be revoked on the basis of their conviction. And then one of the other things is that, having any sort of law enforcement contact, specifically DUI, can simply be what puts you on ICE's radar, or your client on ICE's radar. So we have had people who have pled to DUIs and they go in for their first appointment with probation, and that's when ICE comes and picks them up, or at the time that they plead guilty. Now, if someone is undocumented, they don't necessarily need a conviction for DUI in order to be picked up by ICE, but oftentimes this is what alerts ICE to this undocumented person's presence. So of course, avoiding contact with law enforcement would help in deterring ICE, or not encountering ICE and being arrested by immigration authorities. The last thing I just want to say is that the term conviction is different. It can be different in the Immigration and Naturalization Act as it is in criminal court. So most states have something called a deferred judgment and sentence, or a suspended imposition of sentence, or something of that nature, where the individual pleads guilty and then they're sentenced to some sort of period of probation. And then if they successfully complete that probation, the guilty plea is withdrawn and the case is dismissed. And oftentimes this is sort of the run-of-the-mill offer for first-time DUIs, but it's really, really important to recognize that those are generally going to be considered convictions for the purposes of the Immigration and Nationality Act. Anytime that a person admits guilt in front of a court, or a court makes a finding of guilt and then imposes restraint on that person's liberty, even if the case is ultimately dismissed, those things are going to be considered most of the time a conviction. So I hope that this video was helpful to talk about some of the effects that DUIs have on an individual's immigration status. You are welcome to call our office if you have questions or want to set up a consultation. The Austin office's number is 512-856-4899, and St. Louis office is 314-226-1944. I'm Lindsay Gray in the Austin office. Have a great day. Bye-bye.